Hi, everyone. This is a Know Your Rights presentation that is about the asylum process for newly arrived Afghans. This presentation is a part of our Immigrant Justice Project, and for context, CAIR Washington is a civil rights and advocacy organization serving Muslim individuals, families, and communities in Washington state. CAIR Washington's Immigrant Justice Project team is focused on providing legal representation for newly arrived Afghans in Washington state. And today I'm here with my colleague, Alex Baron, and I'm Angelique Rodriguez. I'm the policy assistant here, and I will open the floor for my colleague.
Hi, I'm Alex. As Angelique mentioned, I'm an immigration lawyer. I've been one for about 9 years, and in most of that time, most of what I've done is asylum, and I'm happy to be here.
Next slide, please. So today we will be covering in this presentation, so what is asylum? What are the components of an asylum case? How asylum is different for newly arrived Afghans? What makes for a strong asylum case? And what to expect as an individual beginning to file for asylum. Next slide, please.
So we'll start with the definition of a refugee, which is, for our purposes, the same as an asylee. This definition comes out of a treaty that the United Nations put together in the wake of World War II and all of the refugee migration that was going on at that time. And it states as follows: asylum is a form of protection which allows an individual to remain in the United States instead of being removed to a country where he or she fears persecution or harm. Under US law, people who flee their countries because they fear persecution can apply for asylum. If they are granted asylum, this gives them protection and the right to stay in the United States. Those who are granted asylum are called asylees. Next slide. So the benefits that you'll get if you are granted asylum include the right to remain in the US indefinitely, permanently, derivative status for your spouse and unmarried children under 21. Derivative status means that they have the same immigration status essentially that you have. And it's also important to note that that includes children who were under 21 at the time of the asylum application. As we'll discuss later, asylum applications can take a long time. So as long as someone was under 21 when the application was submitted, they can be included later if the application is granted. Asylum is a pathway to citizenship, which means that it opens the doorway to another benefit, which means that after 1 year, you can apply for a green card status, as we call it colloquially. Technically, that is called legal permanent residence. And after that status is obtained, you can have that for 5 years, and then you can apply for US citizenship. You also have the permission to work as an asylee. You get a social security number and a social security card. And you will probably have access to many forms of government assistance at the local level, which could include financial, medical assistance, English language programs, employment training. These are benefits that you may find as I said, at the local level. There are organizations that will work to provide them. There is no national centralized office for providing these services for asylees, but there are options at the local level. You will also have the right to travel and re-enter the US. Refugees and asylees, by definition, often are not able to obtain passports from their home countries. And so it's worth noting that if you are going to travel while having the status, you will have the right to apply for what's called a refugee travel document, which serves in place of a passport. It looks like a passport. It may not be accepted by all countries in the world, and there may be different rules, as far as obtaining visas for travels to certain countries, as there would be for a US passport, but you will have the right to apply for and receive that. Next slide.
So here we're going to talk about eligibility for asylum. So there's 4 main steps in determining the eligibility for asylum. So the first is applicant satisfies the definition of refugee. This is something we're going to talk about in the next slide. 2, applicant is not subject to bars to asylum. 3, applicant warrants a favorable exercise of discretion. In other words, the adjudicator decides that you merit asylum based on factors in your life that can be considered either positive or negative. And then 4, the applicant is in the US or at the port of entry. And if you are at the US port of entry, there are many different paths that your case could take, but either way, you must start at the port of entry. Next slide, please.
So here we're going to talk about the terms refugees and asylum seekers. Now, these two terms, as well as the term asylee, are often used interchangeably in conversation about these issues. They all derive from the same part of the law, which we've summarized before, and I'll read word for word now, which states that any person who is outside of any country of such person's nationality, or in the case of a person having no nationality, is outside of any country in which such person last habitually resided, and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So that is quite a mouthful, but I'll just highlight 3 important points. So the person who applies for asylum or seeks refugee status, number 1, has to be physically outside of their home country or their country of last residence. Number 2, they have either suffered persecution in the past or they have a well-founded fear of persecution in the future. And we're going to be talking a lot about how persecution is defined or not defined. And 3, that the harm they fear or have experienced is on account of one of the 5 protected grounds. Those are those 5 grounds that were mentioned at the end: race, religion, nationality, membership in a particular social group, or political opinion. Next slide. So this is a chart that shows the different ways that someone might apply for asylum. There are different routes to asylum. There are different adjudicators that can make an asylum decision. I won't go into too much detail. You could, if you'd like, hit pause and look at this chart in more detail. But I'll just sort of describe the big picture, which is that if you see that top arrow, it's called refugee resettlement process. So that is when someone leaves their country and is typically residing in some third country in unstable status or in a refugee camp. And the United Nations typically takes a lead in getting these people, first of all, getting them temporary housing or getting them other types of assistance and reviewing and vetting their cases. And then their cases are referred to the US government, potentially. And if that happens, the US government does additional vetting. And then finally, if these cases are successful, these people might be resettled to the US with the help of support organizations. Second arrow is called affirmative asylum process. That is when someone has some type of visa to enter the US or or parole in the case of many newly arrived Afghans, for example. So it's some legally issued status to enter the US, and once inside the US, that person can apply for asylum. And the result of that application will be an interview with a Homeland Security officer in an office somewhere. And then the bottom 2 arrows are slightly different processes, but they sort of merge at a certain point. And I won't go into too much detail, but for people who either arrive at the border or a port of entry without a visa to enter the US, or for people who enter on a visa, but at the port of entry, that visa is denied, but the people express a desire to apply for asylum, then that triggers a different process which will result in the person having an appointment in immigration court to present their case before a judge who will make a decision. And that process might involve sometimes a period in detention. And some of these cases are actually completed in detention, and people spend long stays in detention. Next slide.
So now we've talked about what asylum is. We're now going to shift to talk about what the components of asylum includes. Next slide. So the components of a asylum application will include a cover letter, which a letter is telling the officer who is reviewing the case, what documents and evidence is included in the application, and maybe also might also summarize the case. The I-589 form is the asylum application itself, and the G-28 is a form that the attorney signs, basically saying that they are representing you. Then evidence will also be included, and evidence may include declarations, official documents, identity documents, proof of status, country condition reports, medical records, psychological evaluation, photographs, news stories, text messages, audio recordings, really anything that's gonna help you just support your case. It can include more than what was just listed. And then it will also include certified translations, which is basically, so anything that is not in English needs to be accompanied by a certified translation. Next slide.
So I'm going to talk about what the evidence needs to demonstrate. So first of all, the evidence needs to demonstrate that the applicant is unwilling or unable to return to their home country because of, first of all, either past persecution or well-founded fear of future persecution. And again, we're going to talk more about persecution as this goes on. But also, just as importantly, the persecution has to occur on account of one of the protected grounds that were mentioned in the law. So again, those are race, nationality, religion, political opinion, or membership in a particular social group. So just to be clear, it's one thing if there's something bad that's happened or something bad that's likely to happen to the person, but that's not enough for an asylum case. For an asylum case, that bad thing that's going to happen also has to be happening specifically because of one of these 5 reasons. Asylum is also a discretionary benefit, which means that the adjudicator making the decision is going to take into account some positive or negative factors in the applicant's life, even after the applicant has presented evidence and proven their case, so to speak. The adjudicator is going to look at other factors to decide if they are worthy, so to speak, of the discretion to grant their case. So positive factors could be community involvement, ties to the US, like family here, children here, good moral character, and the negative factors could be any sort of criminal activity or criminal convictions. This is a gray area, so really the adjudicator looks at many other factors that I might not have mentioned in making this decision. And finally, the evidence needs to show that the applicant is not subject to any of the bars to asylum, which we'll discuss in more detail as this goes on. Next slide. So now we're going to talk about what is persecution. And this is a great question. Persecution is actually not defined very well in immigration law. You'd think it would be, but it's not. So it is decided on a case-by-case basis. A sort of standard definition from one of the major cases is a threat to the life or freedom of, or the infliction of suffering or harm upon those who differ in a way regarded as offensive. It does not need to include bodily harm or any kind of physical harm necessarily. A lot of people win their asylum cases based on threats that they've received or threats that they're likely to receive. For example, a lot of the newly arrived Afghans who are applying for asylum may not have suffered physical harm themselves in the past, but may have a very strong fear of suffering it in the future. And we'll talk more about that. Persecution can include both physical and psychological harm. A permanent or serious injury is not required if the person has suffered harm. So there may be no lasting effects, and that harm may only be provable through testimony, but that still may be enough to prove persecution. It does have to be more than what's considered harassment or discrimination. And of course, these terms themselves can be vague and subjective. The incidents that a person is afraid of or the incidents that they've suffered should be viewed cumulatively. So that means, not focusing just on each and every incident individually, but rather the total harm that the person is expressing. Generalized countrywide violence is not considered persecution. So what that means is that if there is a lot of violence, if there's a lot of instability, a lot of danger in the country that the person's applying for asylum from, that will not be enough to win asylum. Again, this could be relevant to people newly arrived from Afghanistan. It's not enough to say, look at what's going on in the country. You have to prove that you have a fear of persecution yourself based on one of the 5 protected grounds. So it's very specific. Next slide.
So Alex kind of went over what counts as persecution, and now we are going to talk about who are the persecutors. So the persecutors is the government or actors that the government is unwilling or unable to control. Examples of this might include examples of government actors might include police or military, and then examples of non-governmental actors may include guerrilla and paramilitary groups, family, community members, gangs, etc. So again, who counts as a persecutor? It's either the government or actors that the government is unwilling or unable to control. Next slide, please.
Essential to your asylum case is showing that either you have experienced past persecution or that you have a well-founded fear of persecution if you were to return to your country. So past persecution, first of all, you establish that through testimony, which will be both the written testimony you submit to start your case, as well as the oral testimony you provide when you're being questioned by the adjudicator. If you have proven past persecution, which what I mean by that is if you've satisfied the adjudicator, which could either be an asylum officer at the Department of Homeland Security or an immigration judge, then the burden shifts to the government, which what that means is that you've made your case, and the adjudicator should consider that you have suffered past persecution, unless the government can show that this past persecution you've suffered doesn't mean you're going to suffer anything similar in the future. And the 2 ways that the government can do that would be, one, by showing a fundamental change in circumstances. So for example, you were imprisoned and tortured under one government, and that's why you fear returning to that country. But since that time, that government has actually been replaced by a new government with a totally different ideology, or a new government, based on the opposition movement you yourself were part of, and you have friendly ties with that new government. So that might be one way that the government shows, yes, even though these bad things have happened to you in the past, you are not likely to suffer persecution in the future. The other way the government could possibly rebut a showing of past persecution is by showing that you can relocate within the country somewhere else. So, all of the harm you suffered is in one particular conflict region of the country, or all of it is in the capital city. But if you were to go to a different part of the country, there is evidence from country conditions articles or whatever showing that everything is safe in that country, and you wouldn't be at risk there. That's another way the government can show that even though you have suffered persecution in the past, you're not eligible for asylum. Keep in mind that even if you have not suffered past persecution, you can still win your asylum case by showing a well-founded fear of persecution in the future, on the basis of some of the same factors we've been discussing. And I just want to note also that if for an asylum case that ends up in immigration court, it's important to keep in mind that there will be a lawyer there in your court hearing from the Department of Homeland Security who is acting essentially like a prosecutor would in a criminal court. So that lawyer will be there with the one job of trying to diminish your credibility, of trying to find holes in your story, trying to find inconsistencies, trying to point out that evidence you have does not support what you're saying. So if you're in immigration court, these issues that we're discussing at the moment can become, quite tense, and there can be a lot of argument about these issues. Thanks. Next slide. So, the central part of the asylum application is establishing a well-founded fear of persecution. This is broken down further into two prongs. The person who fears persecution has to have both an objective and a subjective fear. The subjective one is usually the easier one to prove. So that just means that the applicant is genuinely afraid to return to their home country. The person has to give testimony. Any asylum case, the person will give both written testimony when they submit their application, as well as oral testimony when they're asked questions by the adjudicator. And in this testimony, the person has to show that really they are afraid and explain in tangible terms why they're afraid. But then there's also the objective fear that has to be proven. So the objective fear is showing that a reasonable person in the applicant's circumstances would also fear persecution. So it's not something particular to the applicant and their mental state and their personality or anything like that, but any reasonable person in their circumstance would also fear persecution. Standard definition would be that if there is a 1 in 10 chance that this persecution could happen, it would be considered well-founded. And that objective part is usually proven with additional testimony from witnesses, which can be friends or family members who know what the person went through and also know the situation of the country. Country conditions articles, which are usually reports from human rights organizations or articles from journalists. Sometimes we submit expert testimony. So there's a person who's, say a professor or a journalist or someone with particular expertise in that region who can explain why this person's subjective fear is also an objective fear. The process for establishing this point in an asylum case is, or I should say the process that has to be described is that the applicant first possesses a characteristic or opinion that the persecutor wants to repress. And we'll talk a little bit more about this later. Second, that the persecutor is aware of or likely to become aware of the applicant's opinion or characteristic. And then the persecutor seeks to repress it. And finally, you have to show that the persecutor has the capacity to persecute the applicant because basically they have power over the applicant because they're either the government or they're a group the government can't control. Next slide.
Okay, so burden of proof. Again, as Alex already mentioned, asylum is discretionary. It's not like other applications where you just kind of check the boxes and you get it. It's you have to show that you're, so to speak, worthy of being granted the discretionary application of asylum. So when you start, so essentially the people who are going to be adjudicating your case are going to be very suspicious. They will try to figure out if you're trying to make anything up, and in this sense, poke holes in any evidence or testimony you put forth. So it's important that your testimony is consistent, that there are no false documents, no contradictory evidence, and that it's very specific and to your situation and includes detailed descriptions of the actors, the events, the dates, all that important information. Next slide, please.
So as we've mentioned a few times, the persecution needs to have occurred or it needs to occur on the basis of one of the 5 protected grounds, which we've talked about. And as we've mentioned, this is called nexus. An example that we'll give that fits nexus, which means that persecution is occurring on one of the protected grounds. Let's say that protected ground is political opinion. So a case where that fits the nexus would be that there's a political rally going on and you happen to be at that political rally. And the persecutor thought because you were at that rally that you were in support of that political agenda. And then the persecutor persecutes you because of their perception that you support that agenda because you were at the rally. So that would be a factual pattern that would fit nexus. In contrast, if the facts are simply that the persecutors were going through the rally beating everyone who was on the street that day, including people who may not have been participating in the rally, and then and you may have been one of the people who was beaten, but many other people were, including non-participants, and later on there was no indication that the persecutor thought you held that political opinion. That could be persecution, perhaps, but it wouldn't be persecution for a protected ground, and so it wouldn't fit the nexus. And once again, it's important to note that generalized violence is not nexus. So if there are these kinds of crackdowns happening all the time in a certain place because the government's cracking down on political opponents, for example, that in and of itself is not enough to get asylum if you can't show that the persecutor thinks that you hold those political beliefs and that's why they're persecuting you. So this involves an examination both of the applicant's actions or inactions, but also of the persecutor's views. And it's also important to note that a person can suffer, that an act of persecution can occur for many reasons simultaneously. That the person inflicting the violence or the other form of persecution may have multiple reasons in their mind or in their motivation for doing this to this person. But as long as you can show that at least one central reason is tied to one of those 5 categories, then you should be able to establish nexus. Next slide.
So yes, the 5 grounds include race, religion, nationality, which can also include ethnic minorities, tribes. Example would be like Hazara. The 4th one is political opinion, which is not identified or not defined in the INA. It covers a broad range of views. Expressing a political opinion can be done through actions and also no actions at the same time. But again, as Alex already mentioned, it all is dependent on what the persecutor perceives like your opinion to be, for example. Then the other one is social group. So social group is probably the most creative category that allows legal providers to engage in the most creative legal arguments. So if you are looking at these and you are worried that your asylum claim might not fall into one of these categories, there's a good chance that social group can be used to create a more creative legal argument so that you could put forth an asylum claim. It just really comes down to you making sure that you talk to your attorney or your legal provider and communicating so that you guys can build the most strongest case possible. And then lastly, again, all these categories are imputed, which essentially means it depends on what the persecutor perceives you to be. So again, like if we think about the political opinion example, you are at a political rally, so the persecutor thinks that you support that specific political agenda, and that's kind of what it means to be imputed. But it comes down to what the persecutor thinks of you and why they are persecuting you. So yes. Next slide, please. And then here we have bars to asylum. So there are 5 bars to asylum. If you think one or more bars applies to you, be sure to talk to your legal provider to help you navigate your factual situation. And also keep in mind that these are very specific to your situation. Everyone's situation is probably a little different or maybe a lot different. But the main thing is, as we're going through these bars, if you feel like one applies to you, don't don't feel like you can't apply or don't feel like you can't put forth a claim. First, be sure to talk to your legal provider to figure out how to navigate your factual situation. And second, one thing to note is bars to asylum are evaluated during the application process. So if you think that one or more bars applies to you, you can still apply for the application or for asylum itself. You just need to work with your legal provider to make some like creative arguments to work around those bars. Next slide, please.
So one of the bars to asylum is called safe third country. And what this means is that there is some treaty in place between two countries, a bilateral or a multilateral agreement that says that you have to apply in one of the countries first. And really, at the present time, there's only one agreement which is between the U.S. and Canada, which says that whichever country the person sets foot on first is the country where they should have to have their asylum case heard. There are some exceptions. So just as Angelique said a moment ago, if you think this applies to you, definitely talk to your legal provider. If you have a lawyer, your lawyer will probably have some arguments for this. But essentially, if you arrive in one of the two countries, U.S. and Canada, and then try to cross into the other one to apply for asylum, this treaty says that you should actually go back and apply in the other one. This has happened a lot in the past here in Washington, which is a border state, of course, where people who have been able to enter the U.S. on different types of visas have perceived that their chances of winning their asylum case were better in Canada. And they have tried to enter Canada through the Washington, British Columbia border. And if they're apprehended, that those people have been returned to the U.S. and placed in detention and had to complete their cases in the U.S. Typically, if you have a visa to enter the country where you want to apply, this shouldn't come into play. There are some other exceptions. So definitely just talk to your legal provider if you think this is applicable to you. Next slide.
So there is a 1-year deadline. So this is the second bar. So the second bar is like the 1-year deadline. So the applicant must file for asylum within 1 year of the date of his or her last arrival in the U.S. And then, however, there is an exception for this. It's here, it says, unless he or she demonstrates changed circumstances that materially affect his or her eligibility for asylum or extraordinary circumstances relating to the delay in the filing application. So in the next slide, please. Here we have, there are 2 exceptions to filing, to the 1-year filing deadline for asylum application. So first, changed circumstances. This is specifically for the asylum claim itself. So basically, this means that the circumstances that materially affect the asylum eligibility has changed, and now it's possible that you have an asylum claim. So an example might be a person is gay and they can't go back to their home country because a set of laws recently changed and now their own government is persecuting them. So that would be an example of like changed circumstances. Extraordinary circumstances, this is the one that applies to newly arrived Afghans in Washington, in newly arrived Afghans really who are here on parole. So basically this refers to the actual events or factors directly relating to the delay in the filing. So it's not due to that specific case itself, like case specific stuff itself. Basically, this delay could be due to illness, legal disability, ineffective assistance of counsel, maintaining lawful status. So again, if you're on like parole, or if you're a newly arrived Afghan who was evacuated, that counts. So parole or TPS counts as a extraordinary circumstances to the filing deadline. But again, be sure to talk to your attorney about this. So yes, next slide, please.
So the next bar that we'll talk about is previous denial. If an immigration judge or the Board of Immigration Appeals has previously denied your application, then you are ineligible to apply again unless you demonstrate the existence of changed circumstances which materially affect your eligibility. So this is very similar to what Angelique was talking about a moment ago. A material change is a substantial alteration in circumstances that the adjudicator would rely on when determining if you meet the eligibility of an asylum claim. So these could be changes in the framework surrounding the facts, if not the actual facts of the case. So to give another example, similar to the one Angelique spoke about, an applicant, applies for asylum and is denied, and the basis of the asylum claim was that the person feared persecution from gangs in the area where they lived and the country they came from, based on their imputed identity of being gay. But the facts since that denial have changed because now the government in that country has actually implemented laws against gay people. And now that person is not only fearing the activity of gangs and other community members, but that person's actually fearing being arrested on the basis of the new law. This would be a demonstration of a changed circumstance materially affecting your eligibility for asylum and would allow you to apply again and overcome that bar. Next slide, please. So the firm resettlement bar is the next one we'll talk about. This comes up all the time, and it's a really important one to know, or specifically to know that there are arguments around it. But basically what the firm resettlement bar says is that an applicant can be ineligible for asylum if they had any type of firm resettlement, which basically means a stable living situation with the possibility to keep living in that situation in any country other than the country where they fear persecution on their way to the US. So this comes up a lot because very often people who are fleeing persecution in their home country have to pass through other countries to come to the US. Sometimes they flee to a neighboring country and try living there for a while, but they're always fearing being deported to their home country. Sometimes, as is the case really with almost everyone who comes to the southern border seeking asylum, most people will have passed through a third country on the way to the US-Mexican border through human smuggling networks or otherwise. Those people will have passed through many times several countries. And so the first thing that comes up in the analysis of whether that person is barred from asylum is the question of whether they received an offer of permanent residency or citizenship in that country. So if the person has received an offer of permanent residence, then under the law, they should be barred from seeking asylum in the US unless they can show, some other things, which I'll talk about in a moment. But before I get to that, I just want to say that, an offer of permanent residence could be something like what we call green card status in the US. It could be asylum if the person is granted asylum or refugee status in another country. Or if the person is granted some type of temporary status that under the laws of that country should create a pathway to citizenship or residence, that could be argued by the US government to be firm resettlement in that country. If no offer was made, then the person should not be barred and the case should proceed. But if such an offer was made or can be construed by the adjudicator to have been made based on some of these factors I've mentioned, then the second part is that the person has to show that the conditions of his or her residence were substantially or consciously restricted by the authority of that country so that in fact they were not resettled. So for example, a person gets a type of refugee status in the country where they've been on the way to the US, but they're still subject to all kinds of threats and harassment and other persecution by the authorities there or by community members there. This has come up a lot with people passing through countries such as South Africa, for example, where there's been a lot of xenophobic violence against migrants there. So people will have some type of status in the country, but they'll still be subjected to all kinds of threats and violence similar to what they're actually facing in the country where they're fleeing. So if you do have a permanent offer, an offer of permanent residence somewhere, then you can go through some of these factors to show why that should not be counted as firm resettlement. And just to give a little bit more information, some of the things that the adjudicator will look at when trying to determine if you were firmly resettled could include the fact that you married somebody from the third country where you passed through, that you joined a church or some other religious organization, that you got a job, bought a car, that you were able to open a bank account, that you were able to access healthcare, that you were able to attend school or had children who were able to attend school. These are the types of things that the adjudicator will look at to figure out if they're going to find you firmly resettled in another country or not. Especially if there isn't that specific offer of a permanent residence, but there is some other argument that the person was firmly resettled. Make sure to talk to your attorney or to any legal provider if you have passed through another country where you spend a significant amount of time. This is likely to come up in your case, but it is also an issue that comes up in a lot of cases, and in a great deal of the time there is an argument that can get you through it. People who are coming to the U.S. to seek asylum are by and large doing it because they don't have other options. And so part of what's going on when you spent time in another country and you moved on to the US is that there are reasons why you didn't feel safe in that country most of the time. And so those need to be expressed when you make your firm resettlement argument. Next slide. Finally, we want to talk about the terrorism bar. So you might often hear this referred to also as TRIG, which is a terrorism-related inadmissibility ground. If you hear that term in your interview, that's what they're talking about. What this means is that an applicant is found ineligible for asylum because he or she has shown a history of engagement in terrorist activity, including providing what's called material support to a terrorist organization, or having a connection to a terrorist organization, or even being the spouse or the child of someone else who does. Now, this sounds very extreme, and on its face, you would think that this would not affect many people, but in fact, that's unfortunately not the case. The case law that deals with material support for a terrorist organization has defined this in an extremely broad way, and in my view, an unreasonably broad way. So, for example, people who have provided food to armed groups who arrive at their house with guns, saying, "You have to feed us now," and essentially feeling that they're under duress or they're being threatened to provide food. Such people, according to case law, have been found to be barred from asylum because of material support to terrorism. In other words, the case law is holding that food that you provided these armed groups with at gunpoint is material support for terrorism. Other fact patterns that come up a lot are that people are passing through checkpoints that are manned by armed groups who are saying, holding a gun and looking at the person and saying, "You have to give us money to pass through this checkpoint. And if you don't, then who knows what's going to happen to you right here." And if you do that, then technically you are barred from asylum, or actually any immigration benefit in the US, for material support to a terrorism organization. So this is just an extremely broadly defined bar. And in fact, for people newly arrived from Afghanistan, it's something to really consider, because Taliban is considered a terrorist organization. It's an officially designated terrorist organization by the US government. And any interaction with the Taliban, such as passing through a checkpoint, like I mentioned, providing food, family members who could have Taliban connections, all of these things could potentially raise the question for the adjudicator of whether you are barred based on terrorism or material support to terrorism. And so this is a bar that you need to think about and take very seriously. There are waivers. There are certain waivers available, even if the officer or the judge finds that you are subject to a terrorism-related inadmissibility ground. You can, in many instances, seek a waiver of that and proceed with your asylum case. It's not always easy to get a waiver. It definitely adds a lot of time to the case. It's not a position you want to be in, to ask for a waiver at all. So if there is any fact in your story that you think might raise the potential for this question, you really need to talk to your attorney about it and provide as much detail as you can, because it's only with the full context and all the details that the attorney will be able to figure out how you present these facts, what type of arguments you're going to make for why they were not material support, and potentially what kinds of waivers are available to you. Just want to mention that this bar is not only a bar to asylum, but it's actually a bar to withholding of removal too, and it's a bar actually to any kind of immigration benefit in the US. So it's something to be taken very seriously. Next slide.
Okay, so now we've talked about what asylum is and what the basic components of an asylum case are. So now we're going to shift to talk about how this is different for newly arrived Afghans. Next slide, please.
So some things that you want to keep in mind are that, first of all, that asylum may not be the best option for you. For various reasons, you may not have a strong asylum case. You may also have better immigration cases and options available to you. So for example, one thing to always consider is family-based petitions. Certain types of your relatives can petition for a green card for you. Not any relative, but immediate family members typically can. And depending on the ages and relationships of people involved, those might be really smooth cases, and they might go quickly. They might be easy to win. And sometimes family relationship visas are possible, but they put you in a different category because either you're over 21 or you're married or some other reason. And those might still be very good petitions to file, but they might also take a much longer time. So, talk to your lawyer or your legal services provider about this if you do have any family members who are green card holders or US citizens, and see if your options are good for a family-based petition. SIV cases, which SIV stands for Special Immigrant Visas. As many of you probably know, SIVs are good cases if you can prove the eligibility criteria. Typically, SIV cases are for people who either people who worked with U.S. forces or international forces in Afghanistan, providing services of some kind. Talk to your lawyer, legal service provider if you did do any work of that kind. You may have an SIV case. If you do, it's probably a better route for you than asylum for a couple of reasons. It's a non-discretionary type of application, which means that those discretionary factors, those positive and negative factors that an asylum adjudicator has to consider to decide if they really want to give you asylum, even after you've proven your case, that's not a factor for SIV cases. So if you meet the eligibility criteria, you should get a visa, which leads to an automatic green card for you as well as your family members. It also is going to move a lot faster in most cases than an asylum case. We'll talk about this a little bit more in a moment, but typically asylum cases can take years to resolve. There are some provisions for newly arrived Afghans that make that go a little quicker, but asylum is generally a very long road. So if you have something like an SIV case available to you, you definitely want to pursue that as well. Many of the newly arrived Afghans entered the US on what's called parole, which is a temporary authorization to enter the country and remain in the country for a temporary period of time. There will be options to renew your parole very soon. There's also something which is similar to parole, which is called temporary protected status, which allows you to, just as the name suggests, apply for temporary protection in the US. So you can stay in the US without any fear of deportation for a period of time. Parole and TPS are not as good as winning an asylum case because they're temporary and they don't lead you to a green card necessarily. They don't lead you to citizenship. There aren't very good options for traveling in and out of the country, but they are options that are available right now. So you want to consider those. I'll also say that it's not it's not a problem necessarily to apply for several different benefits at one time. So because asylum can be hard to win and can take a long time, you might want to apply for asylum if you think you have a good case, while also pursuing some of the other options that I've mentioned. And again, just keep that in mind, that asylum is not easy to win. You have to have a good case. You have to present evidence to support your case. It's not just enough to tell your story. You're going to need to find witnesses to your story. At the very least, family members or friends that you talked to at the time, who can write letters describing their memory of those events. You need to, again, express a claim of fear of persecution based on one of the 5 protected grounds. And once again, generalized violence in the country is not enough to win your asylum case. A humanitarian crisis in the country is not enough to win your asylum case. The fact that the Taliban is in charge now of Afghanistan, that fact alone is not enough to win your asylum case. You need to express your claim of the fear of persecution based on one of those 5 grounds. Also keep in mind that anything you put in your asylum application or any other immigration application is with you forever, in the sense that immigration has a file containing all of that information. And anything you apply for in the future, whether that be a green card application after winning your asylum, or whether that's applying for a TPS or an SIV case, the immigration officer will be able to look at what you said in one application versus what you said in another application. So facts that you provide about where you've worked, about who your family members are and where they're living, about the different events that happened to you in your life. All of these things will be cross-checked across applications. So you need to make sure that it's all consistent. You need to really be an active participant in your asylum case. You need to be able to tell your lawyer, if you're working with a lawyer, all of the information you can think of that might be important for the lawyer to know, or really anything that might have any connection to the events you're describing. I can't tell you how many times I've seen an asylum case stumble and hit an obstacle because there were facts that were not expressed in the initial application, and they come out in the interview and they shed different light on some of the events that are being talked about. So you really need to be open with your lawyer, and remember that your lawyer is there to advocate for you and support you, and figure out a way for you to present these facts in a way that helps you win your case. And then this has been mentioned before by Angelique in this presentation, but I just want to mention also that if you are here in the US as a newly arrived Afghan and you have parole status or TPS or some other kind of status, and you're past the 1-year deadline and you're worried that you shouldn't apply for asylum now because you're past the 1 year, but you do have a good asylum claim otherwise, you should file for asylum and remember that the parole status or whatever other status you have could be an extraordinary circumstance that allows you to clear that 1-year filing deadline bar for asylum. Next slide.
So the last thing that we want to mention, being different for newly arrived Afghans, is the timeline of the asylum case. So asylum cases can take a very long time. It's hard to really know how long it will take for you to hear back. USCIS has issued a special policy for evacuated Afghans. They stated on their website that asylum cases should be completed with 150 days. Most Afghan asylum cases seem to be taking longer, but are still moving relatively quickly in comparison to non-Afghan asylum cases. Non-Afghan asylum cases take about 5 or more years. So yes, next slide, please.
So we just want to mention in our parting words some elements that make for a strong asylum case. If you're considering filing for asylum, you just need to keep a few things in mind. So with regard to the components of a strong case, you want to make sure that all of the elements of your case are clearly articulated in as much detail as you can articulate them. So for example, if your case is about past persecution, about something that happened to you, you want to be able to say exactly what happened to you, why it happened, who did it to you, and why they did it. One of the details that you can see there that we've listed on the slide, if you say just a man came to my house and threatened me, that won't be enough for the officer or the judge to grant you asylum if you can't provide more. So when you discuss this in the interview, or even in the written testimony that you submit with your application, you want to be able to say, the men came to our house, they had Taliban uniforms, they had guns, they broke down the front door, or they knocked on the door, or something like that. You want to be able to say exactly what they said, not just that they threatened us, but what did they threaten? What did they say they were going to do? What did they want you to stop doing? Did they want you to stop working with US forces, for example, or else they were going to kill you? Something with that specificity. So you want to be able to express those things clearly, even though they are oftentimes very difficult to remember and very painful to remember. Unfortunately, you really have to express and describe in as much detail as you can these terrible things that you might have experienced. If your case is not based on past persecution, but it's based on what you fear will happen to you in the future, you need to be as precise as possible. So, for example, if I get sent back to Afghanistan, I fear I will be arrested at the airport and held in jail because of this, because I did this, or because there's this part of my identity that makes me a target. Or because there is a particular person in my country who's in power who wants to hurt all people who share my characteristic. So, if you are not putting these things in your written testimony when you submit your case, you will definitely be asked to provide them in the oral testimony that you give us, to complete your case. And the officer or the judge asking you questions will not be satisfied with vague answers. In fact, there are asylum cases that are denied for the reason that they are too vague. So you have to be as specific as possible. Again, even though these are things that are often very difficult and very painful to talk about. It's unfortunate, but you will have to talk about them to win your asylum case. You'll also have to think about consistency. So in most cases, when you're applying for asylum, you're going to have to tell your story a number of different times, at the very least 2 different times, in that you're going to have to submit written testimony to start your case, and later you're going to have to provide oral testimony in an asylum interview or in a hearing in immigration court. And you need to make sure that you're telling the same story each time. It could be okay if there are tiny changes in many tellings of a story. That's natural when you're remembering something at different points in time. But the main facts of the story really have to stay consistent. Otherwise, the person adjudicating the case will probably think that you're not able to remember because you're making it up or because it's not true. I say that with the awareness that we know that when our memory is dealing with traumatic events that we've been through, it's often hard to remember those events. It's often the times that are when we revisit those events at different points in time that our memory shifts them in some way. That's a fact. But unfortunately, the people adjudicating asylum cases don't give much weight to that fact. They really want to hear you tell the same consistent story each time. And so you need to keep that in mind if you want to win your case. You also need to make sure that you've evidence about the country conditions that support the facts you're telling. So if you're talking about how you're at risk from a particular ruling party or a particular militia that was powerful at a certain time, you want to be able to show that there are country conditions in the evidence you've submitted, articles or whatnot, that show that really was the case at that time. And then you want to try to get any kind of documentary evidence that you can to back up your claim. So, for example, people who have been beaten, tortured. They may have still have physical symptoms. They may have scars on their body still, and so you want to have a medical evaluation that documents some of those things and is signed by a medical professional who can support that the facts that you've testified to are supported by the physical symptoms or the scars on your body. If you ever received any kind of threat in writing, a letter dropped off at your house, a letter given to you by a superior in the place where you worked, or something like that, you want to see if you can get a copy. And really, any type of thing you can think of, or your lawyer can think of, you want to submit to support your case. And this may not be clear to either of you at the beginning of the case as you start putting it together, but sometimes these types of evidence emerge, as you and your lawyer are understanding better which are the facts that are going to be included in your application. If, for example, you went to a political meeting and you happen to still have a copy of the ticket that you had to buy to go to that meeting, that taking a picture of that and submitting it with your application, that could be evidence. An ID badge for a certain group that you belong to. So anything at all that can help to back up what you're testifying to needs to be submitted. And this is really important because most of the time for an asylum case, you really don't have a lot of evidence because, almost by definition, you're leaving your country in circumstances that don't allow you to gather a lot of documents or to plan very well, I should say to have the opportunity to plan very well. And you're not able to oftentimes get those documents later because you're afraid of your government, and your government means you harm. So really anything at all you can think of to support your case or that your lawyer can think of should be submitted to support your testimony. Thank you. Next slide.
So this is the concluding slide of our presentation, which we just want to leave you off with a link to our Know Your Rights materials. So we have a Welcome to Washington website, and we're uploading all of our materials there, and we're working on providing more presentations on these sorts of applications, so to kind of demystify these very complicated applications. So thank you so much for watching, and thank you to Alex for doing this with me. So
thank you, Angelique. Appreciate it. Thank you.
Okay, thanks. Did we do it?